This is the recorded lecture for Community Corrections, Chapter 3, Sentencing and Community Corrections. So, starting off with the sentencing decision. Once defendants have been found involved or convicted with an offense, they move into the sentencing stage of criminal proceedings, if they have not been diverted out of the formal process. So they have already been found guilty or pled guilty to a crime. The judge must now decide how to dispose of their case or how to handle it, what type of sanction they're going to receive, which is sentencing. So the judge has a wide variety of options at their disposal. They can order a defendant to pay fines. They can order a defendant to probation. They can order a split sentence, intermediate sanctions, or imprisonment. This decision is obviously exacerbated by the high incarceration rates throughout the country. So to think that the overcrowding in the prisons does not impact sentencing would be wrong. Plea bargaining. We discussed this, I believe it was in Chapter 2. The exchange of prosecutorial and or judicial concessions in return for a plea of guilty. So what this is, typically a prosecutor and the defense attorney will agree to something. Sometimes it's a lesser charge, sometimes it's a dismissal of other or pending charges, recommendation for a reduced sentence by the prosecutor, or a combination of these would be considered plea bargaining. So moving back to criminal sanctions and why do we impose them? There's 4 theories listed here. So first we have deterrence. So some would argue that the purpose of criminal sanctions or sanctions for committing an illegal offense, those sanctions would serve to prevent the individual from committing an offense again in fear of those sanctions being imposed on them again. Another side of deterrence is that individuals see the sanctions being imposed on others for committing offenses, and so that prevents other people from committing those crimes because they don't want to face those sanctions or those punishments. So essentially, the deterrence theory would say that punishment or the sanctions involved with committing an offense should deter someone else from committing an offense for fear of the repercussions. Incapacitation, that says that when we lock up an offender, put them in jail, incarcerate them, they're literally incapacitated from committing new criminal offenses. So if we just lock them up, they will not be able to commit criminal offenses. Now, we all know that that isn't true, that those offenses can be committed in prison or in jail, wherever the offender is. But for the most part, putting someone into jail or prison incapacitates them from committing new offenses. The next one is restoration, that you're going to impose a sanction on someone in order to restore the damage that has been done. Rehabilitation, just like it sounds, those criminal sanctions that are imposed on an offender are done so that the offender can learn from their behavior, correct their thoughts and behaviors, and get back on the right track. So it's essentially the purpose then of a sanction would be to rehabilitate the offender. And you can read more about these in your book. They are on page 34. So there's 2 major incarceration outcomes: imprisonment in a penal facility or a jail. The major alternative to incarceration is probation, and there's other intermediate sanctions that can be utilized. Your PowerPoint shows 2: house arrest, sometimes residential treatment. We did talk about intermediate sanctions. I believe it was last chapter, but we're going to touch on them some more later in this chapter. And we also discussed discretion in a previous chapter. So we talked about police having discretion with regard to who they're going to arrest, if they're going to arrest, how they're going to charge them. Then we talked about the prosecutors having discretion with regards to what charges they're going to pursue in court, how they're going to have cases scheduled, things of that nature. So enter judges having discretion. So a lot of sentencing involves judges' discretion. They have, that can range from probation to imprisonment, which is pretty big difference if you're the offender. So if an offender is placed on probation, judges can impose a wide range of conditions, which are also part of the sentencing options that they have available to them. One of those is community service. This is the requirement that the offender complete some type of task that helps the community. And this is typically done at a nonprofit organization, something like a church or any other nonprofit organization in the area. It's considered a form of restitution, and the sentence can be community service just by itself, or it could also be included with some other obligations. I just want to point out here for a brief minute, it's not in your textbook, but a large body of the research indicates that community service really doesn't have any impact on the treatment of offenders or the rehabilitation. And the correction system, criminal justice system as a whole is really moving towards rehabilitating offenders, not so much sanctioning. The juvenile system is light years ahead of the adult system. And since this class, a large portion of this is relative to the adult criminal justice system, I just wanted to point out that, for adult offenders to do community service, it really is just that, a sanction. There's no real rehabilitative or major impact on the offender. It's really just having them do something. So in the juvenile world, we have really gotten away from assigning kids involved with the system community service. There is one caveat to that, though, and that would be if the community service is directly linked to the offense the individual has been charged with. So, for example, I always use graffiti. If a juvenile or even an adult does graffiti on a wall, and then they're charged with vandalism or something of that sort. If they were ordered to do community service and it was to go back to that area and clean up the graffiti that they did on whatever property, whoever property was damaged by that, that would be effective community service, because you're essentially taking the offender back to literally right what they wronged. So outside of those circumstances, community service is not used widely anymore. It's still employed, but as you move into the field, in your jobs, be thinking of that. What kind of impact is community service really having on our offenders? Is it just something we're telling them to do, or is it really having some kind of effect? Home detention. So house arrest restricts the offender to his or her home, typically unless they're at work, and they are given what's called windows to leave. So we might say, all right, you work from 8 to 5. I'm going to give you windows to leave the house from 7:30 a.m. until 5:30 p.m. So that window would be that approved time that the offender is allowed to be out of their house. And it's like your PowerPoint says, unless they're at work. There are other reasons we might give an offender a window. It could be for counseling, it could be for church, anything like that, doctor's appointments. And also, as an offender does well and is compliant with these things, typically they may be given extra windows just for free time until eventually they're able to work themselves off of home detention. The idea of home detention or house arrest is really to reduce jail crowding, but ultimately these offenders have been assessed risk and found that they don't need to be incarcerated. So they're essentially given a chance on home detention or house arrest. If they do well, they won't end up in jail. Home detention oftentimes, probably 95% of the time, involves the use of electronic monitoring, which is that ankle piece that you will see on an offender's ankle. But it doesn't always involve that. So you can simply tell an offender that they're not allowed to leave their house with the exception of certain things, and they're expected to follow that. So home arrest is typically without the electronic equipment. We refer to house arrest as when they have the electronic monitor on, but those are just nuances. Electronic monitoring, this is the ankle monitor. It's an electronic transmitter that sends out a signal and it's attached to an offender. So typically there's what we call a beacon in the house, and then there's the ankle monitor on the offender's ankle. Community residential centers. These are also known as halfway houses. They are programs that provide an option for those offenders to live there. And these are typically offenders that maybe were pretty heavily involved within the system and don't have anywhere to go, or just offenders that don't have anywhere to go. So their step down is from incarceration or treatment to a halfway house, where there's a little bit of monitoring, but they still have their freedom. We're going to spend a whole chapter discussing halfway houses later in the class. Restitution. This is a court-ordered requirement that the offender pay back for any damages that were done. The example I always use is if two individuals get into a fight and one punches the other and they break their nose, restitution would be the money that you pay back to that offender because they had to pay medical bills. It could be if you stole a car and crashed it, you could owe restitution to that other individual, whoever's car it was or whoever's car you crashed into, for the damage that you did. Probation is obviously another sanction. It's essentially a conditional freedom that's granted by a judge. So when we say conditional freedom, we mean the offender has their freedom back, but it's not complete and free freedom. They're not an individual that's completely free. They're not incarcerated. They're in the middle. They're under probation. So they still have terms and conditions they have to follow, but they're not incarcerated. Typically, the offender will have other sanctions they have to do, meet with their probation officer, thing like that. Intermediate sanctions. These are sentences that, now we move the scale up a little. These are sentences that are between probation and being incarcerated. So these are things like boot camps, electronic monitoring, intensive probation, halfway houses, drug courts, day reporting centers are also examples of intermediate sanctions. These examples here on this slide, though, are examples of rehabilitation rather than punishment, which is the way that the system is moving, however slow. Intensive supervision. This is another intermediate sanction. So an individual is already on probation and they're ordered to intensive supervision. It's sort of a step up. They're still not incarcerated, but they're not on regular probation anymore. Intensive supervision is just that. The individual is probably going to be seen at least once a week, potentially more, and oftentimes during after hours or weekends, just to check in on them, make sure they're doing what they have to do. It's designed to provide increased supervision for those offenders that are higher risk. When we say higher risk, we're going to learn about in a few chapters how we come up with labeling what level of risk an offender is when we're going to complete a risk assessment in the course. It's designed to increase prison diversions. So divert people instead of going to prison, let's offer them intensive supervision out in the community. And at the same time, we're still providing public protection or community safety. So those probation officers that supervise cases on an intensive supervision caseload, they typically have less cases or offenders on their caseload than regular probation officers. They are expected to see their offenders under probation much more frequently than regular probation. And a lot of services are put into place for those offenders. Based on their risk assessment that is completed on them, we look at what areas of need those offenders have based on their criminogenic needs and this risk assessment that we're going to complete. And we put those services in place in an attempt to help that individual, to rehabilitate them. So I skipped a few slides, a lot of history stuff with regard to corrections, but I wanted to pick it back up here. So prison overcrowding was already a problem in 1870. So typically when we talk about community prison overcrowding, we start talking in the 1970s, 1980s, the war on drugs, and kind of how that all started. But I was interested to see that back in 1870, this was already a problem. So some leaders within the field, they went and met in Cincinnati, Ohio, and it eventually was the beginning of the American Correctional Association. The American Correctional Association adopted standards and principles for new prison construction, because if prisons are overcrowded, we're going to need to build more. And they also started an early release program. Indeterminate sentencing. This became the dominant sentencing structure up until the 1970s. And your book talks a little bit more about indeterminate sentencing. So the sentencing judge during indeterminate sentencing, they pronounce a minimum and maximum period of incarceration, such as 3 to 5 years, or 5 to 10 years, or 1 to 20 years. Correctional personnel assist the offenders in changing their behavior and preparing for eventual return to the community. And then the parole board monitors the offender, all that. So indeterminate sentencing really is a range of sentence, and different things can impact whether the individual gets out on the lower end of the scale or finishes out their whole sentence incarcerated. So by 1930, most state and federal courts were using the indeterminate sentencing structure. And by the way, that little blurb on indeterminate sentencing is on page 38 in your textbook. The idea kind of behind this was that once the offender is considered rehabilitated, or correction officials have seen positive change and think that the individual is not going to go out and commit these offenses again, the parole board would know that, because they're working with the individual, doing assessments, talking with other corrections staff, and then they would order a release on parole. In 1974, rapid changes began with the restructuring of the whole sentencing process. So some issues that came up that were identified included prisoners being not happy with the idea of rehabilitation and what prison life was actually like. So there were some uprisings in prison. The abuse of discretion that created concerns about individual rights. So we've talked about discretion throughout the stages, and how discretion could impact someone if it was used improperly. Court orders and decisions led to a movement that demanded accountability in official decision-making and outcomes. The rehabilitation ideal was challenged, both empirically and ideologically, which undermined the rationale of the indeterminate sentences parole after rehabilitation corollary. Experimental and statistical studies of judicial sentencing found a large disparity in both racial and class discrimination. Such inconsistencies and disparities fostered the conclusion that these indeterminate sentencing practices were unfair. Some perceived certain politicians as political opportunists when the politicians viewed the records of lenient judges and parole boards, led the public to believe that they were releasing dangerous offenders back into the community. So although corrections in the 70s generally reflected the goal of rehabilitation, other discussions from the reform movement brought additional correctional goals to the forefront. And we're back to incapacitation, that individuals are not able to commit offenses if they're locked up. Giving longer sentences to high-risk offenders. Deterring a crime was a social goal during that time. 3 strikes laws. They exemplified deterrent sentencing. So 3 strikes laws, California has some good examples. I believe they're no longer in effect, but one example of a 3-strike law would be retail theft. You get arrested for retail theft once, regardless of the grading, whether it's a summary, misdemeanor, or felony, and you get arrested a second time, doesn't matter the grading. You get arrested a third time for retail theft, and it's automatically a felony. So your third time, you could have stole a pack of gum, but because it's your third time, it's a felony. So that's an example of 3 strikes. Many more examples. Retribution was the goal. Getting back at someone. They deserve punishment for what they've done. We found that to be largely ineffective, but it is a theory. Just desert strategy looks back, looks back to the offender and wants punishment. So some of the ways that we could reform this process: get rid of plea bargaining. These are options that the authors of the textbook suggested. Get rid of plea bargaining. Establish rules and guidelines surrounding the plea bargaining to make it more fair. Mandatory minimum sentences. Statutory determinate sentences. Voluntary or descriptive guidelines for sentencing. Creating sentencing councils. Requiring judges to provide some type of reason for why they came up with the sentence that they did. Setting parole guidelines to limit the discretion that parole boards have. Getting rid of parole altogether. Adopting or modifying good time procedures, meaning if an offender does well in prison, do they get out early, and exactly what does that look like? Routinizing appellate review of sentencing, so making it so that it's just part of the process that sentences automatically get appealed for review. Sentencing decision has a major impediment. It usually requires that judges predict human behavior. Now think about that for a minute. The judge is the one imposing the sentence, so the judge is the one who's deciding what happens to that offender. So we're essentially placing a lot of power in those judges' hands, which I know everybody knows that judges have a lot of power, but we're really asking them to predict the needs of that human. Do they need to be incarcerated? Do you think they're going to commit this offense again? So we're asking them to predict. It's a lot. Determinate sentencing, a broad condition of interests. Lots happening here, but it resulted in a return to a flat sentence. As of 1998, 17 states created sentencing commissions to restrict judicial discretion. Mandatory minimum sentences have been enacted in all 50 states. 27 states and Washington, D.C. have 85% statutes. Problems in setting prison terms. So control over sentencing has passed from the judiciary to the state legislators. Concerns over disparate sentences and other abuses of the system have resulted in 6 basic strategies to formalize legislative control over the process. Determinate sentencing, mandatory prison terms, sentencing guidelines, parole guidelines, good time policies, and emergency crowding provisions. And we're going back to the 3 strikes laws. Legislation that specifically identifies a group of repeat offenders for lengthy incapacitation, and that really started sometime around 1993. At least 27 states and the federal government enacted these 3 strikes laws. In 2012, Voters in California passed an amendment that would require the third felony. So an individual gets arrested for convicted on one felony, convicted for another, but now when they get their third felony, if it is either violent or serious, they would receive 25 years to life in prison. More recently, some states have enacted laws designed to lessen the punishment for certain offenses. Many of these changes would not have been possible a decade ago. We already covered what a jail is, and we covered what a prison was in Chapter 1. Split sentences. This is sort of exactly what it sounds like. Short term of incarceration for a convicted offender, followed by a period of probation. So the sentence is split. Incarceration, probation. This can include work release, where the offender is allowed to go to work during the day. So they might be incarcerated at the jail, and then from, like, say 8 to 5, they go to work and then they come back to the prison. It's also not uncommon for an individual to spend their week working and then report to the jail Friday, Saturday, Sunday, and then go home, work through the week, and then return to the prison or jail for the, to finish out their sentence. So, to wrap up our session, public protection is the primary mission of the correctional system, but not everyone that breaks the law needs to be incarcerated, which is why we have a community corrections class. And I'm going to put another plug in here that the textbook says the primary mission is public protection. I'm also going to add rehabilitating offenders. We've learned how we went from flat sentences to indeterminate, the creation of parole, our attempts to create alternative sentences, some with the goal of punishment, deterrence, and others designed to help in rehabilitation. Thank you.